I hope you have watched the previous video. No doubts. Okay. So people, hey people, now I want to show you a previous question. People in moratorium, yeah, we discussed one point. Yes. Sir, what was that point? People in moratorium, we saw that there will be restriction, prohibition, suspension on four things. First one, institution or continuation of new suits, transferring, encumbering, alienating, or disposing of the assets. Any action to foreclose, recover any security interest created by the corporate debtor in respect of its property. Sir, now what is this people? Hey, look at this, how and all, what do you say? First thing, yes, whatever I'm saying you people, these are not like the institute asked questions. On this first, there are certain cases in the court people, because there is a, probably a lacuna, there is a not a little, not clear, or it's like very clear. Based on those points, people, they have filed certain cases. So either it has been rejected or accepted, as the case may be. So people, one such word is this word we have written here called its. Now what happened, people, listen carefully. There was a person who was a promoter. The promoter has given guarantee. He has given a guarantee for a creditor. He has given a guarantee for a creditor. Sir, for whom, sir? For a corporate debtor. That is, people, his own company. Now people, the company could not repay the debt, so the company eventually went into CIRP. Now when CIRP initiated, people, the adjudicating authority, he started the CIRP process. So by order, people, he ordered for a moratorium period. Now moratorium period started. ICICI Bank, people, because this person, the corporate debtor, could not repay, he went and he filed a case against surety. And people, whatever are the surety's properties, he was about to take them. Sir, the surety people, he filed a case now. Sir, moratorium, no, sir. You're not supposed to touch anything. This is not possible. Yes, so people, regarding this is the case. I'll say the case once and then let us look at the answer. Measures Systematic Mora Private Limited, appellant corporate debtor, has challenged the order dated 3rd July 2017 passed by adjudicating authority, Mumbai bench, Mumbai, in the National Company Law Appellate Tribunal. NCLT had admitted the application preferred by an appellant under section 10 of the Insolvency and Bankruptcy Code. And order of moratorium was passed and insolvency resolution professional was ordered to be appointed by adjudicating authority. The only grievance of the appellant in its challenge is that the movable and immovable property of guarantor has been attached pursuant to a corporate insolvency resolution process initiated under section 10 against the appellant by LD adjudicating authority, which is violative of section 114 clause 1 subsection 1 clause C of the Insolvency and Bankruptcy Code. Decide. Okay, people, now I hope you understand. Sir, they are taking the action against the guarantor. Sir, he is telling no, you cannot start. So people, here NCLT said this one thing. What? The National Company Law Appellate Tribunal held that when moratorium period is declared, it results in prohibition on any action to recover, enforce any security interest created by the corporate debtor in respect of its property. People, it means what, people? Something which belongs to you. So people, that is the reason, people, this did not apply on the guarantors. If anyone gave people, their assets can be taken. People, after this is when they added one more thing, is what we saw here. Yes, sir. After this, people, is where they added this thing that is called prohibited acts. That is what we saw. It doesn't apply to a guarantee or a corporate debtor. So regarding that is this particular case law, people. Understood, all of you? Got a fair idea? Awesome. So, sir, we did moratorium, public announcement, interim resolution professional, and people, resolution professional. Correct. Replacement we saw. Preparation of information memorandum we saw. Okay, we are going to start one of the very important ones, people. Constitution of Committee of Creditors. Yes, people. Constitution of Committee of Creditors. People, very important. Very important. This committee plays a major role because it is end of the day left to them. Whether they want, the CIRP will go through. If they do not agree, people, CIRP will not go through. As simple as that. So, people, that is what we will be discussing. We will be going in detail for CIRP of Constitution of Committee of Creditors in the CIRP process. Clear, people? Okay. Now let us first see what is there in our summary chart. Okay, sir. Sir, Constitution of Committee of Creditors, people, note 7. Sir, what does the law say? People, first thing, people, who will sit in Committee of Creditors? Sir, people, who will sit in Committee of Creditors? So people always remember the composition of Committee of Creditors. People, by default, one thing I'll tell you. What is that? Yes, people, concentrate. So, sir, in Committee of Creditors, who will sit? People always remember in Committee of Creditors, sir. Okay, imagine a company has financial creditors plus operational creditors. Financial creditors to whom we owe financial debt. Operational creditors to whom we owe operational debt. Imagine, people, for a company we have both financial creditors as well as operational creditors. Now, sir, we are forming a constitution. We are constituting a committee of creditors. Correct, people? People, the law says in the committee of creditors, people, committee of creditors, only and only financial creditors will sit. By default, people, in the committee of creditors, only and only financial creditors will sit. Sir, why? People think financial creditors, people, if you take at the your tip of your fingers, you can count how many people would have given you loan. It will be maximum what, people? 30, yeah. 40 people, everyone would be covered in your financial creditors. People, but think about operational creditors. Operational creditors, people, employees will come, workmen will come, people, government dues will come. Imagine, people, employees coming. How many people will come? So, sir, the law said, you know what? Comparatively, financial creditors would have given money and they would have lost money. Yes, people. So, always remember, whenever a company has both financial creditors as well as operational creditors, people, the committee will only and only consist of financial creditors. Is this clear, all of you? Okay. Let us try to make it this way. Imagine, people, scenario. Imagine, people, committee of creditors. Now, you guys may have this doubt, no? What? Sir, what if a company, sir, no, sir, we will not get this doubt and all. Imagine, I'll only create a doubt. What if a company has only financial creditors and no operational creditors? There is no operational creditors. People, then it is obviously very easy. When we'll form a committee only of financial creditors. Fair enough. Imagine, people, a company does not have financial creditors, but it has only operational creditors. Sir, now what to do? Sir, now what to do? People, always remember, when we don't have a choice, what else we'll do? People, when we don't have a choice, we will form a committee with operational creditors only. Remember this. When a company has financial creditors plus operational creditors, we will not consider operational creditors at all. But, people, if at all we don't have any financial creditors, what other choice you have done? So, people, you can form committee of creditors with only operational creditors. Keep this in mind. It should just go book inside. Is this clear, all of you? Okay. Now, before going to committee, all this you need to have it in mind. Okay. Sir, imagine, people, I'll show you an example. How it looks. People, I hope it's going inside. Yes. Okay. See, people, Videocon's Hey, by the way, you guys know that Videocon is in corporate insolvency resolution process. Videocon. Yes, our household name for your electronic. It was once upon a time like that, right? People, now look at this. Out of the total claim amount of 71,433 crores claims admitted. So people, Videocon, our actual Videocon, people, Videocon and its units, people, it's around Videocon and its connected units, people, almost around 13 units. Almost around 13 units, people. On all these 13 units, a CIRP has been started. Videocon and its 13 units. I'll show you how what is going on. A resolution plan was submitted and the resolution plan was also kicked out. We'll see what is that. See, out of the total claim amount of 71,433 crore, claims admitted are for 64,838 crore. People, 71,000, imagine the 71,500 crore worth claims were submitted. In that, adjudicating authority, insolvency resolution professional took only 64,838.63 crore. Other can be people totally havoc, blunt, or no proper records, such cases. And the plan is approved for an amount of only 2,962 crore. People, there is one company, I'll tell you the name. I think it's Star some health or something. One sec. It was a absolutely disaster resolution plan, people, and that was accepted also. People, this twin star technologies, now what happened, people, this the company created committee of creators, all that happened. Information memorandum was prepared. Resolution applicants, they were called to submit resolution plans. One of the resolution applicant was Twin Star Technologies. Yes, people. So he gave a bid, people. He said, I will take over the company. People, this is the amount of creditors, people. Where did that go? And he gave a quote, people, I will take over the company for 2,962 crores. Yes, people, 2,962 crores, which is only 4.15% of the total outstanding claim. I told you haircut, and the total haircut to all the creditor is 96%. 96%. You know what? For operational creditors, 99.38% or something was a haircut. People, they got somewhere around 0.72%. Sir, is this plan approved or no? Now people have appealed on that plan. How can someone approve that? Now Adani, who is the other person? Adani, Jindal, Ballari, Jindal factory. All these people have, even they shown their expression of interest. So this is what is going on. See what all it happens. If possible, try to give a read of Videocon CARP process. It's very interesting. You'll be able to learn more. See, Adani Properties Jindal Power Limited submit expression of interest for Videocon Industries and its 12 units. Videocon and its 12 units. See, this is what I told you. They have appeal. In the parallel development, Supreme Court is scheduled to hear on Monday an appeal by the winning bidder, Twin Star Technologies. People, you know what? The committee of creditors agreed the resolution plan. This resolution plan was given to NCLT. NCLT also approved, people. And then what happens here? An appeal by winning bidder, Twin Star Technologies, that is 2,900 crore wala, against the Jan 5th NCLAT order, which prompted lenders to restart the resolution process. Sir, ye kya hai, sir? Sir, we'll see, people. Yes. So this again. These people are the promoters. Who are they? Your Doot, Venugopal Doot. All these people. Now see here. Okay, I'll try to show you the other time. Basically, on 13 units of Videocon, they have started CIRP process. Yes, people. Okay. Now, sir, people try to understand this one. Sir, imagine people, Videocon is there. Yes, sir. Now, people, in Videocon, who and all will sit? Sir, now the Videocon people, once IRP is formed, he will form a committee of creditors and he will accept all this. After accepting all the claims, he will form a committee of creditors. He will give it to adjudicating authority that have formed it. Everything is done. Okay. Now, who and all will be there in committee of creditors? That is what we are seeing now. That is what I showed you now. Now, people, let us see who and all sits when. People, when a company has financial creditors, when company does not have financial creditors. Sir, when a company has financial creditors, so financial creditors exist, then people, the COC shall comprise of all the financial creditors. People, imagine if we had 35, 40 financial creditors, all the 40 financial creditors will sit in the committee. There is no upper limit. Sir, 60 people, all 60 will sit in the committee. 80 people, everyone will sit. All the financial creditors have a power to participate in the constitution of committee. Is this clear? Okay. Now, people, when financial creditor does not exist, when the financial creditor does not exist, sir, why doesn't he exist? Because of the corporate debtor does not have any financial debt. The corporate debtor has not borrowed any loan. He is not supposed to pay any loan. So company does not have completely financial debt. Or people, the company has financial debt, but all those financial creditors are related parties. So people, always remember this. If at all you are a financial creditor and if you are also a related party, people, then you cannot come and sit in the committee of creditors. But for this, there are certain exceptions down the line. We'll see that. If you're a financial service provider, we'll see that. Conversion is there, but we'll see that. We'll come back to that point. Sir, so till now, what did we see? If at all your company has a financial creditors, people, then everyone will sit. Sir, if the company does not have, why don't you have? Sir, either because we have not taken any financial debt, or people, all my financial creditors are related parties. What decisions will they take? So if you are a related party, you cannot come, you cannot vote in the meeting. You do not have that, liberty. Is that clear? Okay. Sir, then the committee shall be as follows. So people, when we have, then it is easy. When we don't have, what will the committee consist of? Now see people. Sir, what is the number of operational creditors? What is the number of operational creditors we have? Sir, we have more than or equal to 18 operational creditors. Sir, how many operational creditors we have? People, the law said, people, if you have 18 or more than 18. Sir, we are looking at a case where we do not have financial creditors. Sir, we have operational creditors. How many people? First case, 18 people or more. Sir, then the law says people, imagine how many? 18 means it's easy. All the 18 people will form the committee of creditors. Sir, if the company has more than or equal to 18 people, 18 operational creditors, then the law says people, then the committee of creditors will be formed by such 18 operational creditors. Sir, now the question is, what if my company had 50 operational creditors? People, then the law said, whenever a company has more than 18 operational creditors, then you will take the top 18 by value. You will only take the top 18 operational creditors by value, and that will form committee of creditors. Is this clear, people? All of you? Okay, sir. Now, sir, less than 18. Sir, if my committee has less than 18 people, then obviously we don't have any other choice. If it is 17, 16, sir, 10 people, everyone will form the committee of creditors. So all, because it is less than 18, no? So all of them will come and become operational creditors. So all the operational creditors will come and sit in the committee of creditors. Is this clear? Yes, sir. Okay. Sir, and sir, one representative elected by the workmen, and sir, one representative elected by all the employees. So, sir, what do you mean by this, sir? Imagine people, my company has only operational creditors. Correct, sir? People, whenever there is only operational creditors, the constitution of committee of creditors will consist of 20 people. Register it here. The committee of creditors will have 20 people. Yes, sir. When 20 people, whenever we have 18 or more, 18 or more operational creditors, then people, we will take the top 18 and people, one representative each for employees and people, one representative for workmen. So people, employees will nominate one person and send, workmen will nominate one person and send. So people, it will be 18 plus 1 plus 1. So whenever a company has more than 18 or equal to 18 operational creditors, we will have 20 creditors, operational creditors in our committee of creditors. Imagine people, if at all the number of operational creditors are less than that, imagine it is 10. So people, it will be 10, all the operational creditors plus one representative of employees plus one representative of workmen. So people, my committee of creditors will consist of 12 people. People, this is what I wrote here. Sir, this representative of workmen, representative of employees, will they come in? Say for example, if we have financial creditors, will they come, sir? No, people. If there are financial creditors, then these people will not even be entertained. People, is this clear, all of you? Sure, pakka? Okay, sir. Now people, sir, we have formed the committee of creditors. Okay. Sir, person not entitled to participate in the committee of creditors. Sir, we have formed the committee of creditors. Correct. Sir, the persons not entitled to form the committee of creditors. People, these people are not entitled to participate in the committee of creditors meeting. Sir, who are they, people? The financial creditor or the authorized representative of financial creditor. So the financial creditors or the authorized representative of a financial creditor who is a related party of corporate debtor. People, yesterday we saw the related parties definition, all of you, which was similar to your independent director. We saw, I hope you guys remember. So people, such a financial creditor, sir, how, sir? People, try to imagine like this. Sir, there is a ICICI bank. Yes, people, the law says, if these people are also the shareholders. Okay, let us not take ICICI Bank. Later I'll be giving you a note, so you may get confused. Imagine, people, there is some normal company, XYZ company. This company is a shareholder of corporate debtor. How much, sir? These people hold 70%. So they are holding company. So people, now these people have also given them loan. Debt also has been given. So people, even though you have given debt, you will not form part of committee of creditors. We will not take you as a person to the committee of creditors. Why? Because you will obviously take biased decision. Are you getting the point? Okay, sir. So people, now see. So who is a related party of corporate debtor? People, these people shall not have any right to participate, represent or vote in a meeting. So people, they will not come. People, they should not participate. They should not be represented by any other person, or people, they should not even vote in the meeting. Is this clear? All of you? Pakka? Okay. There is one exception. This is what I told you. There is one exception. What is this exception? Sir, if a person is a financial creditor, yes, he is regulated by a financial sector regulator. Sir, there is a person who is a financial creditor. He is a person, he is regulated by a financial sector regulator. Sir, who can that be? Let us take an example of ICICI Bank. Sir, this person is regulated by RBI, financial sector regulator. Now people, ICICI Bank had given a loan, imagine, to Videocon. Okay, sir. Now, sir, Now this is what we have seen so far. This person is a financial creditor because he has given a loan. Correct? Okay. Now what else it says? See here. Sir, financial creditor, he is regulated by financial sector regulator plus he became a related party. Sir, this ICICI Bank became a related party. How? Solely on account of conversion or substitution of debt into equity share prior to insolvency commencement date. Sir, now what is this, people? People, this is very, 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 very important. Why, people? The same note you will be seeing at least another 5 to 6 times. Even when we are doing people ineligible to be called as a resolution applicant, you will be seeing there also this 2 to 3 places again it will come. It's a very important thing. Listen carefully. Sir, imagine people, ICICI Bank has given 2 loans. Imagine people, this is given on 1st January 2020. Imagine people, this was given on 1st January 2017. Okay, sir. So people, ICICI Bank had given 2 loans. Okay. Now people, because Videocon company has made a default. What is the default? People, they have not repaid this money also. Whatever was earlier given, this money is also not repaid. So people, what did ICICI Bank do? Imagine it was a convertible debentures or any other convertible security. So people, because they did not repay the money, people, they had to convert this entire loan amount into equity. Because of default of repayment, people, they had to convert this entire amount into equity, and because of which they became equity shareholders. It is not because they purchased the shares. It is because of the default, people, they had to convert their debt amount into equity. People, if at all you became a related party because of such transaction, which happened prior to the insolvency commencement date, so people, when they are asking for this loan back, people, ICICI Bank will not be considered as related party even though he is a shareholder. Sir, again, sir, people, listen carefully. First thing, he should be a financial creditor. Correct, sir? Second thing, you have to be regulated by a finance sectoral regulator. It is mandatory. Sir, who all can come? Imagine people, asset reconstruction companies, even they are regulated by financial sectors. Yes, people, say for example, people, SEBI is also a financial sector regulator. So people, you can be any of those companies, you are regulated by any of these financial sector regulators. Okay, sir, financial creditor regulated by financial sector regulator. Okay, and people, this person had given a loan before insolvency resolution process started, and people, that was defaulted, and people, because of the default, they had to convert it into equity shares, because of which they became related party. People, even though they are related party, they can still participate, they can still vote, they can still be considered as a normal financial creditor in committee of creditors. Clear or not clear? Now read this once. Exception. So generally people, a financial creditor cannot participate in a committee of creditors if you are a related party. Exception. You should be a FC regulated by financial sector regulator. You became related party because of conversion or substitution of debt into equity shares prior to the insolvency commencement date. Yes, people, is this clear? All of you, pakka? Awesome. Yeah, you're all brilliant. Hey. Okay. First, we'll see the entire provisions of committee of creditors, people, and then let us see some questions also. Yeah. Okay. If any person is financial creditor and operational creditor. Sir, if any person is a financial creditor and operational creditor. Now, what do you mean by this, sir? Imagine people. Okay, now only I'll explain you of people. You keep this one thing in mind. What is that, sir? Imagine people, let us take the example of Videocon. Okay. Videocon had financial creditors as well as operational creditors. Okay, sir. Financial creditors, people, imagine, let us take like this. There is Imagine our allottees of house. Possible they are there. Okay, even they people, they have, imagine there are two real estate projects going on. So project 1, imagine project 2. There are two projects going on. And the people, there is a normal company. This company has given us debt. People, there is one more bank. Let us take the bank, ICICI Bank. They have given us again some loan. And the people, imagine there is a group of banks. Say for example, this is called as consortium lending. People, what do you mean by consortium lending? Mean people, consortium lending means nothing but group lending. It is considered as group lending. Sir, what do you mean by group lending? People, group lending means there will be multiple banks. Multiple banks together, they come and they give a loan to one company. This most of the case it happens in many companies, but this happened with one of the companies, that is your Kingfisher. They come together and they give a big loan, because imagine a person would want 2,000, 3,000 crores. It is too much for one company to bear that risk. So what will the banks do? The bank will lead from the front and it will ask the other banks also, hey, this is the thing, do you want to participate? He will not be responsible. He'll just ask. If you are interested, bank 2 also will join. Bank 3 interested, bank 3 also will join. Is this clear, people? All of you got a fair idea? Sir, imagine people, bank 1 gave, okay, sir, allottees under project 1. Imagine people, we have to pay them around, say 10 crore. Project 2 people, imagine it is a cost of around 50 crore. A company which gave a debt people, imagine some non-convertible debt people, let us take around 100 crore. ICICI Bank gave a loan, let us assume 500 crore. Bank 1 people gave 100 crore. Bank 2 gave 200 crore. Bank 3 people gave, say for example, let us take 300 crore. Okay, the company also had operational creditors people, operational creditors, whoever has supplied our goods. Let us imagine a raw material supplier. Okay, and raw material supply people, we have to pay him around, say for example, 5 crore. People, we have also defaulted in paying our employees. Sir, employees people is 2 crore. And sir, we have to also pay to some electricity and all those things. Yesterday we saw, no, electricity, all those things. Sir, imagine electricity also is around 3 crores. This is what we need to pay. Workmen, there are more also. Okay. Sir, now what is our total debt? People, now Videocon's total debt. Videocon's total debt. People, 10, 50, 60 people. This is 600. This is how much people? This is all 600. So people, 1200, 1260, correct? Sir, 1260 is your total financial credit people. Operational creditors people. Sir, how much is it? Sir, 5 crore, 2 crore, 3 crore. You want more? Let us make something round figure. Let us take it as 55 crore. Yes, now it has become a little bigger. Okay. Let us assume people the total operational credit was 60 crore. Now people, the total debt of the company is 1320 crore. Now people, in committee of creditors, whenever they are voting, there will be voting rights given to the committee of creditors. You guys saw, no? Whenever that 66% we saw, we'll see whenever 66% when it comes and all. Now people, sir, what will be my proportion of voting? What will be my proportion of voting? So people, first thing what you need to do, from the total debt, for whom will we form financial, committee of creditors? Only financial creditors. People, now what I will do, I will have to take this collectively, that is 1260. People out of 1260, now how much does this person have? Project 1, 10%. I mean 10 crore. How much it is? Try to find out. Yes, people, imagine. Sir, the 500 crore is coming to somewhere around 39.6%. Yes, sir. This 10 crore is coming to how much now? 10 divided by 1260 into 100. So this is coming to 0.79%. So people, in this way, everyone will get a vote. So people, the 100% vote will be taken on this 1260 crore and not on the 1320 crore. Keep this in mind. So sir, the proportion of voting always, people, will be the proportion of your debt in the financial debt. Is this clear? All of you, keep this in mind. Okay. Now, what are we seeing? So now we saw a question. What? Sir, imagine there is a financial creditor. Who people? Let us take ICICI Bank. Imagine people, ICICI Bank has given loan of 500 crore. Also people, ICICI Bank has given certain services, the banking services, for which they have given an invoice around say 10 crore. Yes people, sir, ICICI Bank is given 500 crore worth loan and 10 crore worth services. Let us add them here. ICICI Bank, banking services. Some service you have given, for which the bill is around 10 crore. Imagine people. People, the law says whenever you are a financial creditor as well as operational creditor, when I am counting your debt for the proportion of voting, sir, your operational credit part will not be added. So sir, for me, your debt is only 500 crore as long as you are a financial creditor to participate in the committee of creditors. I am not telling you will not get the 10 crore. The 10 crore will be treated as operational creditor. Are you getting this point? All of you. Just that whenever you are voting, your voting will not carry the 10 crore worth of percentage of voting. Is this clear? Okay, sir. In the same thing will apply people. Imagine there is an operational creditor. In our case, let us take employees. Sir, the employees have transferred all their rights to ICICI Bank, who is already a financial creditor. Sir, operational creditor, imagine in our case, let us take raw material supplier. Sir, he has transferred everything, the 55 crore to the ICICI Bank. ICICI Bank also has to get 500 crore plus their 10 crore worth operational credit, correct? Sir, the law says even if an operational debt has been transferred to a financial creditor, it will still be remaining as an operational debt only. You cannot add it to the financial debt. I repeat people, imagine if there is any operational creditor and such operational creditor transfer his debt to a financial creditor. People, this will be considered as an operational debt of the financial creditor now. It will not become a financial debt just because you transfer it to a financial creditor. Is this clear and am I clear? Hey people! Okay, now see. Sir, a voting share shall be proportionate to financial debt. Correct? Total financial debt to proportion of that there will be your voting share. Sir, he shall be considered as an operational creditor to the extent of his operational debt. If operational creditor has transferred his debt to financial creditor, such assignee shall be considered as an operational creditor only. Is this clear, people? All of you, pakka. Awesome. Okay, the next provision is coming. Yes, people, the next topic is called, people, your authorized representative. Authorized representative. Sir, now what do you mean by authorized representative? People, it may so happen that the financial creditor, it can be so many people, financial creditor. We have seen one person. What? Imagine people, there are debenture holders. Imagine there are deposit holders or any securities. So people by which we have raised money. Sir, all of them are financial creditors. Yes, sir. All of it is financial debt. Now people, imagine if all the financial creditors come to the meeting, how it will be? We have issued debentures to, imagine, say 2000 people. Can, if everyone comes, where will you go, da? So people, the law says, the law has given them an option to appoint an authorized representative who will, who will come and who will represent all this class of creditors in the meeting. So sir, that person is called as authorized representative. So people, for a financial creditor who is a securities or deposits holder, they all can nominate one person as a trustee or agent, excuse me, shall be authorized representative. So people, the securities or the deposits holder, imagine debenture holders, people, they have debenture trustee. They can appoint him only as authorized representative. So people, that person will go and present all these people. Is this clear? Okay, sir. Next one, people, the class of creditors. Sir, class of creditors, meaning what, people? Our home buyers, the allottees. Sir, whenever there are allottees, sir, in that case, what will happen? People, now in our case of debentures and all, there is absolutely no problem. In case of debenture holders, we absolutely have no problem. Why? We already have debenture trustee. We know how this particular industry works. People, now what about us? Now say for example, we are all home buyers. There are so many people like us who are, hey, what is it? It came so fat. Imagine people, there are a lot of home buyers. Okay. Now people, there are so many people for so many projects. People, now what to do, sir? People, the law says you guys can collectively nominate one person who is an insolvency professional. So people, these people together, they will again nominate a one person who is called as insolvency professional, because he needs to know how it functions. So people, a person who is appointed, he will also be an insolvency professional. But people, don't get confused. This insolvency professional is not our IRP or RP. They are different. Yes, you can nominate any other person as insolvency professional who will come and act as an authorized representative on behalf of you. Is this clear? All of you? Okay. Sir, now the doubt is what? Sir, we are so innocent, sir. How, where will we go in search of all these people? How will we know where is what? We don't know who is a insolvency professional. Sir, please save us, sir. So people, law gave one option. What? Whoever is the insolvency resolution professional, people, this person will suggest 3 names. He will give 3 names of IPs. Insolvency professionals. He will give these people 3 names of insolvency professionals. Mr. A, Mr. B, Mr. C. Now people, all the allottees, that is your class of creditors, that is whoever is our home buyers, all of these people will nominate a person. People, there will be voting. Whoever gets the majority, 51% vote. People, let us assume Mr. A was nominated collectively. People, Mr. A will now represent all these people in the meeting. I repeat, people, our insolvency resolution professional of corporate debtor, he will give an option to the home buyers or allottees, 3 names. You can select any one name from these 3 names. That name will be taken and he will be appointed as a he will be appointed as an authorized representative of our allottees. Is this clear? All of you read. IRP gives a choice to choose from 3 insolvency professionals to act as their authorized representative. Such selected name of insolvency professional shall be forwarded to adjudicating authority for appointment before constitution of committee of creditors. So all these things happen before constitution of committee of creditors. You think we are doing all this to make sure we form the committee of creditors only? No. Nonsense. Correct or not? So people, certain financial debt can also be represented by. So people, certain financial debt can also be represented by. People, we have already seen this: guardian, executor, administrator. I told you, guardian in case of lunatic, unsound mind. Executor, administrator, a person who will try to enforce your will. Yes, people. Sir, voting. If authorized representative represents several financial creditors, if an authorized representative represents several financial creditor, then he shall cast his vote for each financial creditor in accordance with the instruction received from each financial creditor. So imagine people, there are several people who have nominated one authorized representative. Sir, like, imagine people, I'll give you an example. It is also called as consortium financing. We have just now seen. Sir, in this what happens, people? Imagine there are three banks. Bank 1, Bank 2, Bank 3. So people, these three people have given loan, imagine, to Videocon. Sir, when giving loan, people, all this will be in one single agreement only. One single agreement between people, Bank 1, Bank 2, Bank 3 and Videocon. One agreement will be there. Such type of financing is called as consortium financing. Now people, in this case, what will happen? In this agreement only, they would have written a person's name. Imagine people, Mr. A. If at all tomorrow anything happens, these three banks would have written one person name called Mr. A. This person will represent us in this particular committee of creditors or any other court or any other disciplinary proceedings. Yes, people, such name will be written in this agreement, whatever is your loan agreement, in that only it will be written. Is this clear? Okay, sir. Now what happens? Now people, there was a default. CIRP started. Even now people, you have a choice. What is that choice, people? Whether if you guys want, you can individually appoint your own agents to go. That is, they may send their directors. Everyone individually, they may send their directors. Or people, they may even appoint an insolvency professional. They may appoint agents, they may appoint insolvency professionals, or people, whoever is our Mr. A. Mr. A will only come as an authorized representative on behalf of all these three banks. Okay. So now how much to vote? Imagine people, B has given somewhere around 100 crore. Let us take it as 10%. We have seen it here only, in our case, we'll see here only. Yes. So people, imagine this comes to say 10%. Let us just take a wild number so that you will understand better. Imagine this is 20%. Imagine this is 30%. So people, all of us appointed Mr. A. Correct? Sir, now Mr. A people, bank 1 will tell A, for me it is no. So people, bank Mr. A will have 3 votes. So people, on behalf of B1, whatever B1 tells him to do, he will do that. So he will say no. B2 says for me it is yes. So people, for B2 he will say yes. For B3 he says yes. Okay, let us take for B3. B3 did not say anything. B3 has not intimated anything. In such cases, he cannot vote at all. He should abstain from voting. Sir, now B1's vote will be considered as 10%. B2's vote will be considered as 20%. I hope this is clear for all of you. Clear? Sure, everyone? Awesome. Da. You're all sharp. Da. Hey. Now read whatever we just saw. If AR represents several financial creditors, then he shall cast his vote for each financial creditor in accordance with instruction received from each financial creditor. If no instruction received, then he shall abstain from voting. Is it clear? Decision shall be taken on. Okay, people, this, let us look at it in the next thing. Yeah, I've given it here. It is more appropriate here. Yes. The same point. Whatever you saw there, it is same thing here. Third one. So I'm just taking it away from here. It's the same point there also. Yeah, let us avoid multiplicity. Okay. Sir, in case of consortium arrangement, each financial creditor may authorize trustee or agent to act on his behalf in committee of creditors to extent of his voting share, or they may appoint an insolvency professional at his own cost to represent himself in committee of creditors. So agent or insolvency professional or the other person, that is whoever is the authorized representative, return your agreement, people, he can only go. That is what we saw here. Yes, so one person only come, or you can send them individually also, that is also fine. Is this clear, people? So people, this is what is authorized representative. Okay. Sir, next one, people, meeting of committee of creditors. Sir, now in meeting of committee of creditors, what all will happen? I've put everything here only, people. First one, sir, whenever there is a committee of creditors meeting, people, you need to give a notice. Yes, sir. So people, the notice of meeting. Sir, how many days notice I need to give? People, you need to give minimum 5 days notice in writing to every participant. Meaning, people, phone calls is not allowed. Writing can be even electronic also. Oral is not valid. So minimum 5 days notice in writing to every participant we need to give. Sir, who is that every participant? People, we will be giving notice to. It shall be given to all the members of committee of creditors, all the members of committee of creditors, authorized representatives. So authorized representatives also we will be giving. Next one, people, operational creditors or its representative if the amount of their due is not less than 10% of the debt. People, whatever is the total debt of the company, if the company also has financial creditors, people remember this point, sir, to whom will we give our notice of the meeting? Imagine, people, the company has financial creditors and operational creditors. So people, our committee will have only COC. The law says you can also give a notice to the operational creditor also. To whom? To whom, people, a company owes minimum 10% of the total debt. Imagine, people, the financial creditors plus operational creditors, whatever is the total debt, if at all you need to give to any one operational creditor, that is to minimum 10%. For him also we can give a notice of the meeting. But people, it is bakwas da. Why? That person can only come and attend the meeting. He can't vote. Nonsense only. I'll tell you. I've given you a note. And people, we will also give a notice to members of suspended board of directors or partners of the corporate debtor. People, whoever is our management, imagine my managing director, directors or partners, we will give a notice to them also. Sir, why? People, imagine when the meeting is going on, we would want some small information. How is this happened? What is this figure? So we want someone to justify there, so we will give it to them also. So sir, we will give it to all members of committee of creditors, whoever is the list we have formed, authorized representatives, operational creditors, or the representative. If amount of their due is not less than, people, all employees put together, representative only, no? I hope you're getting the point. Or all the allottees put together, representative only, no? Sir, their due should not be less than 10% of the debt. Members of suspended board or the partners in the case of partnership of the corporate debtor. Clear? Okay. Sir, minimum how many days notice? 5 days notice. Sir, can I give a lesser notice? Sir, can I give a shorter notice than 5 days? It is possible. The law says, people, shorter notice is possible. Sir, shorter means what, sir? People, you can even give a notice less than 5 days also. Ironically, people, they have not mentioned whether it is clear days or unclear days, unlike your AGM. So people, so generally what we do, the date of giving the notice will be excluded. So imagine if I give on 1st February 2022, the 1st Feb will be excluded from the days of counting. So I'll count on 2nd, 3rd, 4th, 5th, 6th. But even people, the industry people should, to be even more safe, they will give it, if the meeting is on 7th, they will give it on 1st. That is, they will exclude the date of giving the meeting as well as the date of giving the notice as well as the date of the meeting. They will exclude all this. Yes, So people, sir, shorter notice possible. How short? People, it can be less than 5 days, but it cannot be less than 24 hours. you need to at least intimate 1 day prior. That is 24 hours prior. 1 day means 24 hours prior. Meaning, sir, imagine today 4 o'clock evening is a meeting. Sir, can I intimate them yesterday at 3 o'clock? Possible. Correct? Yes, sir. Sir, less than 5 days, but not less than 48 hours. Sir, what is this? Two things. People, very simple. Da. If at all any person is being represented by authorized representative, then people, you need to give them minimum 48 hours notice. If there is any authorized representative. Sir, if there is no authorized representative, there are no authorized representative people, then you can give notice as less as 1 day notice is also fine. But if any person is being represented by authorized representative, then the law say people, you need to give at least 2 days notice. You technically try to think why. If you give 1 day, 2 days notice, authorized representative should collect the decision of the committee of creditors whom he represents. Correct? There is one more process. That is the reason we give him more time. Sir, now when do we have to conduct the committee of creditors meeting? People, whenever the resolution professional finds it necessity. So people, the resolution professional, IRP became RP after the first meeting. So whenever he wants people, he can call. Or on a request made by the members of the committee of creditors. Whenever the request is made by members of the committee of creditors, not equity shareholders. When the members of the committee of creditors holding 33% of the voting share, 33% of the voting share, not number people, I'm counting in value. So 33% of the people, if they request for a committee of creditors, then people, we will conduct a committee of creditors. I mean, we will conduct the meeting of committee of creditors. Sir, and one thing to remember, sir, the first meeting of committee of creditors shall be held within 7 days of filing the report by insolvency resolution professional to adjudicating authority on constitution of committee of creditors. So people, first you will raise all the claims. People, 7 days time will be given and 2 days time people, and after that, after getting the claims, within 2 days, the insolvency resolution professional, interim resolution professional, he will file an application to adjudicating authority that the committee of constitution of committee of creditors has been done. So people, once we have intimated, we have 7 days time to file, to hold our first meeting of committee of creditors. Is this clear? Awesome. Sir, next one, people going inside at any given point of time, if you think it is more, pause it, go recap everything and come. IBC important, very important. They will go in depth and question. That is the reason I'm covering you this, as well as the PDF, as well as your questions. People, whatever is best I am giving the, and rest of it is left in your hands. People, quorum. Sir, quorum, people, what is quorum? In board we saw minimum members to be present. Sir, the members holding 33% voting share. So people, remember, the conduct of the meeting 33%. Quorum also 33%. Sir, when they are present, people, either in person or by audio or visual means. So people, the committee of creditors meeting can happen either in audio, that is your audio visual means, people, or it can even be a personal physical meeting also. Both are valid. Sir, committee of creditors may modify this percentage if they want. Committee of creditors, people, they can say 33% all is too less. If everyone agrees, people, then we will make it 40%, 50%. That is also fine. Yes. Sir, if quorum not present, then people, meeting is adjourned. Same thing we saw in board meeting also. If quorum is not present, the meeting will be adjourned to same time, same place next week in board. Correct? People, here it is next day. If at all today the quorum is not present, then you will have to conduct the adjourned meeting tomorrow. Don't write off next week. Clear? People, what if even in the adjourned meeting quorum is not present? The law says, whoever came, they are the quorum. Sir, Jojo Aya, wo quorum. Clear, people? And place on the next, people. If quorum not present, meeting is adjourned to same time and place on the next day. Even in adjourned meeting, if quorum is not present, people, members present shall be the quorum. So if 10% is present, 10% only will be quorum. 20%, 20 only will be quorum. Clear? Awesome. Sir, voting. Now, whatever I told you, cross-reference. All decisions of the committee of creditors shall be taken on 51% of the voting share. Sir, in this particular section, people, they have given what? All decisions of the committee of creditors shall be taken on 51% of voting share. What 51 da? Here only we are taking 33%. Sir, in one place we saw 66%. Sir, what is this? People, listen to this carefully da. In the act, in various places they have specified various percentages. We'll see. I'll take you to one. Now in committee of creditors only, in one place, people, everything will come under 66%. If they want to pass any decision, then 66% of the committee of creditors has to agree to it. In few places, you guys saw 33%. In few places, there will be 90%. Sir, if there is nothing prescribed, the law says then you have to pass everything else with simple majority. So people, if anything else is prescribed, that section will be followed. Sir, if nothing else will be prescribed, people, then 51% will be followed by default. I hope this is clear, all of you. Pakka, yes, went inside. That is what is the note I have given. Unless otherwise prescribed. If something else is prescribed, you follow that. Sir, meetings can be attended by creditors in person or by electronic means. So people, this is what I told you. It can be physical or else also electronic also. Note. Voting, we are seeing a note for voting. Also I've connected to the notice also. That's the reason you can see double arrows. Note, one operational creditors representative, comma, board or partners may attend the meeting. We saw here, no? Authorized representative, authorized operational creditors, one authorized representative, and we are giving notice to board of directors, also partners. Correct, sir? Can they come to the meeting? Yes, they may attend the meeting, but they shall not have the right to vote. They should just come and listen. That's all. Is this clear, all of you? Pakka? Yes? Okay. Now people, there are some more points to cover from the book. Okay. Now see these people. Approval of committee of creditors for certain actions. I told you that 66%, this is the one. What is this? According to section 28 of the IBC, the resolution professional during the CIRP process shall not take any of the following actions. So our resolution professional, in order to do all these things, he has to first take the prior approval of the committee of creditors. Though we have appointed a resolution professional, whatever you want you do, but if you want to do these things, you first come and ask our prior approval. They may ask you to try to remember. Sir, what is that first one, people? To raise any interim finance. I told you yesterday. Yes, people, to raise any interim finance in excess of the amount decided by the committee. Committee told you can raise interim finance up to 20 crore. If you want to raise more than that, then come and take committee of creditors approval. Create any security interest over the assets of the corporate debtor. So people, you're borrowing some money, but you're creating some security over the assets of the corporate debtor. Already we are fighting da. We want some more security, sir. Venama, chahiye. You need to take approval. Change in capital structure. People, change in capital structure. How? It can be by issuing additional securities or creating a new class of securities, or people buyback, redemption, or in any case, people, either you want to increase or decrease your capital, you need to take the approval of committee of creditors. Interim finance connected to that security and people connected to that asset. If at all you want to increase your capital structure or decrease your capital structure. So next one, record any change in the ownership interest of the corporate debtor. Sir, now corporate debtor is a owner for certain assets. Sir, he is making any changes in that. Yes, people, not possible. You need to take COC approval. Give instructions to financial institutions maintaining accounts of the corporate debtor for a debit transaction from any such accounts in excess of the amount as may be decided by the committee of creditors in their meeting. Sir, what do you mean by this? Imagine people, Videocon's accounts were maintained in ICICI Bank. People, and we want to send some money. Now the resolution professional wants to use some money from the account. So people, committee of creditors would have given a limit. Up to this you can use. Now you are giving an instruction to the banker saying that, can you please withdraw? Can you give me a approval for giving more money? Meaning, I told, imagine committee of creditors have instructed ICICI Bank, you can easily approve anything up to 2 crore rupees. Now, this person wants to do a transaction up to 5 crore rupees. Now, give instructions to financial institutions maintaining accounts of the Videocon for a debit transaction, payments from any such accounts in excess of the amount as may be decided by the committee of creditors. So, committee of creditors have given a limit 2 crore. Now, he is going beyond that. Yes, people. Sir, next one, people. Sir, undertake any related party transactions. We have seen related party transaction, people, same Companies Act. Sir, amend any constitutional documents, MOA, AOA, you want to amend anything in that, people, then you need to take approval. Delegate its authority to any other person. People, you have approved or you have given, committee of creditors have given power to resolution professional. Resolution professional wants to again give it to someone else. You need to take prior approval. Dispose of or permit the disposal of shares of any shareholder of the corporator or their nominees to third parties. So people, imagine there are certain shareholders in our company. People, I'm trying to dispose their shares to any other third person. Sir, he is giving, I have certain shares of a shareholder. Sir, those shares I'm taking and I'm giving it to someone else. So people, dispose or permit the disposal of shares of any shareholder of the corporator or their nominees to the third parties. Sir, next one, people, make any changes in the management of the corporator or its subsidiary. You're appointing a director, you're appointing a new person, you're removing them. Transfer the rights or financial debts or the operational debts under material contracts otherwise than in the ordinary course of business. So people, your company has some financial debts, operational debts. People, that money you are transferring it to someone else. Yes, people, you are giving that to someone else. Transfer rights or financial debts or operational debts under material contracts otherwise than in the ordinary course of business. You are giving your rights to someone else. Yes, people. Make changes in the appointment or terms of contract of such personnel as specified by committee of creditors. So people, whoever have been appointed, sir, those people's power have changing. Sir, those people, we have already people. Make changes in the appointment or terms of contract of such personnel as specified by committee of creditors. There are certain people, sir, we have appointed them. We want to make any changes in the terms of appointment. People, you need to take COC approval. Make changes in the appointment or terms of contract of statutory auditors, internal auditors of the corporate debtor. So people, you CAs or your internal auditors, people, if I want to make any changes to your terms of contract, that is, I'll decrease your appointment period, I'll decrease your remuneration. So I need to take committee of creditors approval. So people, the resolution professionals shall convene a meeting of committee of creditors and seek the vote of creditors prior to taking any of the above actions. No action shall be approved by committee of creditors unless approved by a vote of 66% of the voting shares. 66%. This is what I told you. Where any action is taken by the resolution professional without seeking the approval. Sir, I have not taken and I have done this act. Such actions, people, will be considered as void. Is this clear, all of you? At the conclusion of a vote at the meeting, the resolution professional shall announce the decision taken on the items along with the names of the members of the committee who voted for or against or decision or abstained from the voting in the decision. Once the entire decision process is completed, the resolution professional will say whatever is the decision we had to pass, whether it is passed or not passed, how many of them voted for, how many of them voted against, how many of them abstained from voting. The entire report will be read in the meeting. Yes, people? Okay. Now, once just look at your book also once so that everything will be covered. Constitution of Committee of Creditors. Yes, people, ideally, It shall comprise of all the financial creditors. People refer point 7. In that only I told you, where there are no financial creditors. The corporator owes financial debts to two or more financial creditors as a part of consortium or arrangement. These people shall be determined on the basis of the financial debts owed to them. What is that? We'll see down. Persons not entitled to participate in COC. A financial creditor or the authorized representative of FC who is a related party to the corporator shall not have any right to represent, participate, vote in a meeting. Yes. Above shall not apply to a financial creditor regulated by a financial sector regulator, whatever we saw after the conversion. What is consortium lending? I've just given you a meaning of it. In case any person is financial creditor as well as operational creditor, we saw all the three scenarios, correct? One is you will be considered as financial creditor. For operational creditor, you are operational creditor. If there is a transfer of operational creditor to financial creditor, you will be still considered as operational creditor only. Yes, people, that is what we saw. Okay. In case of consortium arrangement, people loan given by group of banks. Now read this once. Where terms of financial debt extend as a part of consortium arrangement or a syndicated facility. Both people same. Where there is a lead bank, one who will come and it will be a group lending. That's all. Yeah. Provide for a single trustee or agent. Facility provides for a single trustee or agent to act for all financial creditors. Each financial creditor may. So people, they may authorize the trustee or agent to act on his behalf in the committee of creditors to the extent of his voting share. This is when our agreement only had the name of Mr. A. Or he may represent himself in the committee of creditors to the extent of his voting share. People, I will only personally come. Or I will send my agent. Imagine I'll send my director if I'm a company. So people, whoever we collectively appointed, people, this is like a Mr. A. Imagine people, ICICI and which other bank? The HSBC, say Yes Bank. Sir, consortium lending people. We have all authorized Mr. A as our, agent or trustee in our loan agreement. So people, the first one is you can send Mr. A only. Mr. A will represent according to your voting share. Next one, people, you can only personally go. People, that is HSBC says, hey, you guys do whatever you want. I will go personally. I don't want him to represent me. So people, HSBC, whatever it will do, it will send its director generally. Okay, third one, people, he may appoint an insolvency professional other than the resolution professional who is already doing the process at his own cost. Correct? Exercise his right to vote to the extent of his voting share with one or more financial creditors jointly or severally. So people, so you can jointly or people, you can do it your own way also. That is also possible. Clear? Voting by authorized representative of class of financial creditors. 21(6)(a). If a financial debt is owned by a class of creditors, allottees, an insolvency professional can be appointed, allottees, by an adjudicating authority on receipt of application from IRP. Sir, who will that authorized representative be? Who can act as authorized representative? People, if it is a financial debt in the form of securities or deposits, and the terms of the financial debt provide for appointment of a trustee. Imagine debenture trustee. Such trustee or agent shall act on behalf of such financial creditors. On all behalf of them, people, this person will act. Where a financial debt is to a class of creditor other than what is mentioned above. People, this is basically allottees, home buyers, popularly called as home buyers. And whenever people, I'm just giving you a heads up, whenever you see the words, section like say 21(6)(a), 12(a), whenever you see this, these are amendments. After the case laws, they would have added these things. Yes, so keep that in mind. Where a financial debt is represented by a guardian, executor or administrator. Yes, people, such person only shall act as authorized representative on behalf of such financial creditors. Okay, so this is what I showed you, people. The interim resolution professional shall offer the names of 3 insolvency professionals to be voted upon by the class of creditors who must be. Now what is this, sir? People listen to this very carefully. Imagine, sir, there are two projects happening in India. Sir, one is in, say, for example, okay, let us take it here only. Imagine, people, there is one project which is happening in Bangalore. So that is, say, Karnataka. Okay. Now, sir, whenever I'm appointing an insolvency professional as an authorized representative, sir, that insolvency professional, from which state he can be? The law says, people, wherever your majority of the operational creditors are there, that is your allottees. So people, this insolvency professional should also be from such place only. So sir, in our case, even that person should also be from Karnataka. Let us take an example where, sir, what if Karnataka does not have any insolvency professional? Imagine. People, the law says then you can pick it from your neighboring states, which is very near. So you need to take geographically which is near. So you will take such IP and you will appoint such person. Read. So the interim resolution professional shall offer the names of 3 insolvency professionals to be voted upon the class of creditors who must be from state or union territory, which has the highest number of creditors in the class as per records of the corporate debtor. Where such state or union territory does not have, then people, the insolvency professional having address in a nearby state, as the case may be, shall be considered. Clear? Sir, now what are the rights and duties of authorized representative? He shall attend the meetings, people, and he will vote on behalf of each financial creditor to the extent of his voting share. And whatever, people, it shall be the duty of authorized representative to circulate the agenda and minutes of the meeting of the committee of creditors to the financial creditor he represents. I told you, whatever agenda we receive, we should intimate him. After the meetings, minutes of the meeting will be given, we should intimate that also to him. Cast of vote by authorized representative, we have seen this, people. If authorized representative represents several financial creditors, then he shall cast vote in respect of each financial creditor. If no instruction, people, he shall abstain from voting. Decision at the meeting, people, it will be taken by, I've given you a note also, 51%. If anything else is prescribed, you can follow that. The committee of creditors shall have the right to require the resolution professional to furnish any financial information in relation to corporator at any time during the CIRP. So if the committee of creditors, people, if at all at any given point of time, if they want any financial information of the corporator, they can ask for it. This person has to give it. The resolution professional shall make available any financial information so required as mentioned above within a period of 7 days. Whatever they ask for, you have to give it within 7 days. Composition of committee, we have seen. Sir, to whom and all we have to send notice? Members, suspended board, operational creditors. I've given you a note also. People, voting share means the share of voting rights of a single financial creditor in the committee of creditors, which is based on the proportion of the financial debt. So whatever is my money out of the financial debt, that will be my proportion owed to such financial creditor in relation to financial debt. Is this clear, all of you? Pakka? Yes? Huh. Each creditor shall vote in accordance with the voting share assigned to him based on the financial debt owed to such creditor. However, voting rights of the committee with only operational creditor will be in proportion to the debt due to each creditor to total debt. So people, whenever an operational creditor comes into picture, people, then the law says it will be the total debt. So you need to take the total debt, and in that, what is the proportion? Total debt is always FC plus OC, correct? And whenever there is FC, people, OC will never be even sitting in the committee. So it will be only operational creditors only, correct? See, whereas the total debt will be equal to debts due to the creditors, workmen and employees. Whatever is the money you need to pay to creditors, workmen and the employees, everything will be there in total debt. Remember this can be important. Yeah. Filing of report certifying constitution of committee. We have seen this within 2 days. You need to intimate adjudicating authority. First meeting people 7 days. Compliances during the meeting. Meeting people representing 33%. Notice for meeting people 24 hours. 48 hours. Quorum we have seen people. Approval of committee of creditors for certain actions. Awesome. So people, this is your committee of creditors. Read this thoroughly, very important, and then watch the next video. Clear all of you? Sure. Awesome.